Welcome to this brief overview of the criminal case process in Pennsylvania. Let's break down the key stages of this process from start to finish. Please be advised that this is intended to be a general overview and should not be mistaken for legal advice. If you have specific questions, you should consult with an attorney. It all begins with a crime being committed. After a police investigation, a person can be charged with a felony, misdemeanor, or summary offense. Felony charges, such as murder and kidnapping, carry the highest penalties, while misdemeanor and summary offenses carry lower penalties. Next comes the preliminary arraignment. This is the first court appearance after an arrest. The charges are read, bail is set if the defendant is not released on their own recognizance, and the defendant is informed of their rights, including the right to a lawyer. Next comes the preliminary hearing, which is held before a magisterial district judge. This is where the prosecutor presents evidence to convince the judge that there's enough to move the case forward to trial. The defendants individually or through the assistance of an attorney can also testify or present evidence. After hearing this evidence, the judge will decide if the case moves forward to trial, often referred to as being bound over, which would be held before the Court of Common Pleas. If the case moves forward, there is a formal arraignment. This is where the defendant is provided with a copy of the charges against him or her in an information or indictment and officially enters a plea. The defendant can plead guilty, not guilty, or no contest. If the defendant pleads guilty, there is often a plea bargain that is negotiated between the prosecutor and the defendant. This may involve agreeing to a lesser charge or a reduced sentence in exchange for a guilty plea. If a plea deal isn't reached, the case goes to trial. The prosecution presents its case, the defense presents its case, and a jury or judge decides guilt or innocence. If found guilty, the defendant is sentenced. Sometimes a probation officer will prepare a pre-sentence investigation report for the court. Sometimes the court may order other assessments, such as mental health or drug and alcohol evaluation. At the sentencing hearing, the judge determines the punishment. The judge must consider Pennsylvania's sentencing guidelines. Some offenses require a mandatory minimum sentence. The judge may order a sentence that could include jail time, fines, probation, or a combination of these sentencing alternatives. After sentencing, there might be an opportunity for an appeal. This is a request to a higher court, which could include Superior or Supreme Court, to review the case for errors. If a conviction is overturned, the case could be dismissed or returned to the Court of Common Pleas for the defendant to be resentenced. Remember, this is a simplified overview. Every case is unique, and the legal processes can be complex. It's essential to consult with an attorney for advice specific to your situation. If you like our content, don't forget to like, subscribe, and share it with others. Thank you for watching.